SJC-12645, Jordan P. Sandman v. Commonwealth.
Mr. Sandman, before you start, let me say Justice Kafker is recused from this case because he was the single justice. Justice Lenk is not here, but she's not recused, and she is watching the proceedings, and she will be involved in helping us to decide the case. So for this case, as for all cases today, you should know that Justice Lenk is effectively virtually here. She will be listening, and she will be discussing the case with us at the conclusion of the oral argument. So with that, Mr. Sandman, you've got 10 minutes, sir. Good morning.
Yeah. Good morning to the court. I hope you're all doing very well today. Before I begin, I'd like to thank you for taking the time to review my case in its entirety. I don't mean any of this perfunctorily. I'm beyond grateful for this opportunity to prepare, speak my mind, and perhaps make a difference. Now, as I prefaced in my brief, I've never disputed any allegations or decisions made by the courts. I've always taken responsibility and paid the price for my wrongdoings. However, I'm here today because for the first time in my life, I've been accused of something that I didn't do, and I know that there's an incredibly strong chance I could have already been home, rebuilding my life and being the father that I love being, had I not been denied a meaningful opportunity to prove that. Now, my understanding of the law is that it's comprised of three basic elements: official authority, enforcement, and regularity. Regularity to me suggests a degree of predictability which should be manifested by the Constitution and the doctrine of precedent. With that said, every citizen should be able to expect that predictability would exist on both sides of the law.
Mr.
On the
Sandman,
one side, there's enforcement.
Sir,
on the other side, yes, sir.
Could I just ask you to slow down a little, please?
Yes, sir. I have 10 minutes prepared, and I actually forgot to ask, is it okay if I have an extra minute on the clock?
If you slow down, the answer is yes.
Yes, sir. I apologize. With that said, every citizen should be able to expect that predictability would exist on both sides of the law. On one side, there's enforcement. On the other side, there's due process. Now, over the past 9 months, I've struggled with understanding exactly what happened to me here, and I've concluded none of it resembles due process. And I'm not an unreasonable person. I know due process is a flexible concept and can vary from one hearing to the next, that the courts are extremely congested, and that there's an ever-increasing need for everyone to be as efficient as possible. I know these things and I understand. I'm not claiming here that the courts and my lawyers had it out for me. I'm claiming that within 13 days, I was arrested, I was rushed through court, I was denied the chance to speak or prepare for 3 separate hearings. I went through 2 different lawyers to no fault of my own. Then I was sentenced to 2 years in jail on a case I've already served 14 months on. All within 13 days. Before I could even blink my eyes, my whole life changed for the worse, and this is after working tirelessly to do the right thing for myself. Now, there are 6 fundamental due process requirements during probation violation proceedings: written notice of the claim violations, disclosure of the evidence, the opportunity to be heard in person and present witnesses and evidence, the right to confront adverse witnesses, a neutral and detached hearing body, and a written statement by the fact finder as to the evidence relied on and reasons for revoking probation. Now, these requirements have existed since 1973, following Gagnon versus Scarpelli, and I say this specifically to underscore my point earlier about how predictability should exist on both sides of the law. Any individual being surrendered by probation should be allowed to expect these things to happen. There's also the district court rules for probation violation proceedings, which break down these requirements. Rule 3BI states that when a criminal complaint is issued against a defendant who is the subject of a probation order, the probation department shall commence violation proceedings against that probationer. Such proceedings shall be commenced by the issuance by the probation department of a notice of violation and hearing. This notice shall be served on the probationer in hand, and this service shall be recorded on the case docket. There's Rule 4D, which was expanded on in the rules commentary as well as in the footnotes of Commonwealth versus Morse, where it states at least 7 days notice of the alleged violations are required, and at least 7 days between appointment of counsel and the hearing. Rule 5C states that the probationer shall be allowed reasonable time to prepare for the hearing, and he shall be entitled to be heard in opposition. Rule 6F states that the probationer may cross-examine all witnesses, whether presented by the district attorney or the probation officer. Now, I literally did not know that I was being surrendered by probation until the day of July 11, 2018, and this is because these due process requirements and rules of the court I just went over were not enforced in Newburyport during the 3 hearings that transpired within those 13 days. Also, neither one of my lawyers prepared me for, discussed with me, or explained to me any of my rights within those 13 days. Bottom line, I was never served in hand those notices. My case docket reflects only that they were filed, which is not the same thing. Those notices were in fact handed to the lawyer appointed to represent me at arraignment, Attorney Hanrahan, who never told me about the notices and then was taken off my case a week later by my next lawyer, Attorney Rogers from the CPCS. Now, nowhere does it state that the probation department may serve those notices upon counsel of the probationer. It says right there in the notices in bold print that they must be served on the probationer in hand. Truth be told, it wasn't until August 25th, 2018 that I would see those notices for the first time when they were sent along with my discovery by the third lawyer appointed to represent me. Now, I asked Attorney Rogers on July 11th to get a continuance, and I had good cause, and that was that I needed time to gather evidence and witnesses. But she told me that there was nothing that I could do. She said that the court would not and did not grant a continuance and that I could not appeal the sentence. Both turned out not to be true. Now, Attorney Rogers was just as unprepared as I was. She had just taken over my case the night before my final surrender hearing. If you see on my docket, it says Attorney Hanrahan withdrew and Attorney Rogers filed her first appearance both on July 11th. Now, right then and there, I was entitled to a continuance according to Rule 4D. But Attorney Rogers didn't tell me that. She didn't explain to me any of my rights. She didn't know any of the facts in my case, didn't know that I was on probation, didn't consult with Attorney Hanrahan before my final surrender. She knew nothing about me. She literally winged it, and I'm still to this day paying the price. Now, citing Commonwealth v. Morse again, the validity of a probation revocation process is not to be determined by whether it satisfies an inflexible code of procedure, but rather by whether the probationer has received fair treatment, which depends on the circumstances of each case. And yes, a colloquy was conducted, and I was found in violation of probation by admission. However, my answers to the judge during that colloquy were based only on the false information I was given by Attorney Rogers that day. Now, had I known then what I know now, I would not be sitting here in front of you today, and that is a fact. Now, following the day I was sentenced, I never heard from either one of those lawyers again, despite the countless times I tried contacting them. Yes, I was abandoned by my lawyers and left to my own devices. Yes, had the court subpoenaed the phone records and attorney visits from the jail, the record would have shown I was left to represent myself for more than 5 weeks. Now, it took me 40 days to procure the documentary evidence I needed to show that I was falsely accused. 40 days after my arrest, August 7, 2018, I filed an application for criminal complaint against my girlfriend for her wrongdoings, along with material documentary evidence proving that she lied in her sworn statements to the police in 3 different instances. And these lies were not immaterial. They showed that she could not be considered a reliable, trustworthy, credible witness. And I should add that she was the state's only witness. Now, back to June 28, 2018, the date of my arraignment, a 209A hearing took place first. If I was afforded due process in that moment by way of continuance, if I had time to prepare for that hearing, if I could have presented the evidence that took me 40 days to gather, the 209A would have been denied. The Commonwealth would not have had probable cause to hold me on dangerousness. My probation officer would not have commenced violation proceedings. The new case it strongly could have been dismissed, and I could have been released immediately. I had material documentary evidence proving that the alleged victim in my case was lying. But because the courts are forced to rush through all their cases in a given day, and because the majority of these cases have merit, cases like mine where a human being becomes victim to somebody maliciously abusing the system get lost in the shuffle. Now, during the 3 hearings that transpired in those 13 days, I knew nothing about due process, which is why I didn't speak up. I didn't know that I could speak up. The root of this problem here is that we are uninformed. Our constitutional rights and due process requirements are not posted on the walls of the holding cells in our courts, which means we are left to rely solely on the instincts of our lawyers and expect that in every case, in the midst of all this rushing, that they're going to make the right call for us. Now, talk about a burden. I mean, on all of us, really. Now, as for the Commonwealth's argument, they've been saying all along I've been circumventing the system, that I haven't exhausted other avenues of relief, that I've been making bald assertions of fact, that my case isn't appropriate for a 211-3 petition. I beg to differ. The record will show that I've made roughly 50 different pro se filings to date. Nobody in good conscience can say that I haven't been following the proper channels. To sum it up, this 2-year sentence I'm serving right now is the result of a conjuncture. A conjuncture is defined as a combination of events creating a crisis. Also, Effective assistance of counsel is defined as a conscientious, meaningful legal representation whereby the defendant is advised of all rights and the lawyer performs all required tasks reasonably according to the prevailing professional standards in criminal cases. To put it plainly, this was a textbook example of court-induced ineffective assistance of counsel, compounded 3 times over, making it a clear abuse of discretion for the single justice to deny my 211-3. Which brings me to my conclusion. My circumstances have changed completely since I was arrested. I'm sentenced. I've served 9 months so far. I've earned 85 days of good time. I'm eligible for parole next month. In September, I was indicted on the new charges that were the basis of my revocation. With good time, my out date would be December 4th. Everything is different. At this point, there's no chance of a do-over. And if that's what the court wanted, it would require starting over completely, which means I'd have to be rearraigned in district court. I mean, there's just no way of giving me due process now the way it should have been given to me back then. It's impossible. I don't have a time machine. This is why I'm asking the court, please, in the best interest of justice, vacate my sentence and previous probationary status, both with prejudice. Thank you again for your time and consideration, everybody. And for what it's worth, it's been an honor to be here in front of you today. Please be well.
Thank you, Mr. Sandman. Ms. Semmel, do you wish to be heard?
Just briefly, Your Honor.
Why don't you speak so make sure with the microphone so that Mr. Sandman can be sure to hear you?
Of course. I would just reiterate the Commonwealth's petition from his position from his brief, that the defendant is essentially challenging the revocation of probation and the legality of the sentence that was imposed, that the appeals court is the proper forum for that. Because of that, the defendant has not satisfied his burden of showing an absence of adequate remedies, and thus there was no abuse of discretion or clear error in the single justice's denial of his petition for relief.
Now, I gather he has filed a notice of appeal with regard to the probation revocation.
I believe so.
Do you know what its status is in the appeals court?
I do not. I don't think it hasn't been docketed. I'm not sure if it's been assembled yet.
Do you know whether he's filed a motion to vacate the revocation based on ineffective assistance of counsel in Newburyport?
I know he filed a motion to reconsider the revocation, which was denied. I'm not sure that he raised ineffective assistance in that claim, but certainly he could do so, and that is another avenue of relief.
Okay, thank you.
Thank you very much.